Chapter 23. Criteria of Domicil, residence and engaging in business, mode of living, ownership of real estate, etc. SS 410. Residence and engaging in business. Residence in a place and engaging in business there have generally been considered as evidence of animus maendi, the value depending much, however, upon the length of the residence and the nature of the business. If the latter be of an apparently permanent character, or, as in Cockrell v. Cockrell, of great lucrativeness, the presumption is strong, but in many cases engaging in business for even a long time has been held insufficient to show a change of domicile. Thus, in Jop v. Wood, it was held that a Scotchman engaging in business in India for 25 years did not thereby change his domicile, and in Recaptiviel it was similarly held with regard to a Frenchman who had resided and engaged in business in England for 29 years. And for further illustrations, the learned reader is referred to the cases already mentioned under the discussion of the effective length of residence. With regard, however, to the case of Jop v. Wood, it may be said that in order to raise a presumption of animus maendi in India, or indeed in any other Eastern country, somewhat different and more cogent facts are necessary than would be required to found a similar presumption with respect to any European or American state. The general presumption of fact founded upon the usual practice in such cases, being that an European residing in an Eastern country expects ultimately to return to his native country. SS 411. ID. Opinions of the civilians. The civilians seem to have been inclined to look upon the fact of engaging in trade as an indication of temporary residence rather than otherwise. This was doubtless mainly because formerly residence for such purpose was usually but temporary, permanent settlement in trade being an exception and very far from the rule. But with the development of international law and the greater protection given to the rights and property of foreign subjects by the governments of almost all countries in the most modern times, the disposition of men to settle permanently for purposes of commerce in foreign countries has increased, and has occasioned a modification of these views. SS 412. ID. Municipal domicile. In cases of municipal domicile, residence and engaging in business is ordinarily accepted as strong proof of animus maendi. SS 413. Place of residence preferred to place of business. As between residence and place of business, the former is preferred as the domicile, particularly as we have seen in the case of a married man who resides with his family or returns to them at intervals. In determining the effective residence, the sleeping place is an important element. If a person have more than one dwelling house, the one in which he sleeps or passes his nights will govern. If he works and boards in one town and sleeps in another, the latter is to be preferred. SS 414. Mode of living. In Morehouse v. Lord Chelmsford says, in a question of change of domicile, the attention must not be too closely confined to the nature and character of the residence by which the new domicile is supposed to have been acquired. Domum autem accipimus in propria domo, quis habitat, sive in conducta, sive gratis, sive hospidio receptus sit, and what is here said of domus might with equal propriety be said of domicilium. La via garcanus sun principal etablissement dans sa petite chambre solitaire, comme le plus opulent peer de famille dans un hotel, comme le négociant dans sa maison de commerce. The apparent or avowed intention of constant residence, not the manner of it, constitutes the domicile, says President Rush in an oft-quoted passage in Gear v. O. Daniel, and he goes even so far as to say, on a question of domicile the mode of living is not material, whether on rent, at lodgings, or in the house of a friend. But this last expression is not strictly accurate, for while the mode of living is often of little importance, yet it is not always so, inasmuch as it sometimes, indeed often, serves to throw light upon the intention of the person whose domicile is in question. Thus it is much easier to presume a change of domicile when a person goes to a new place and there buys land and erects for himself and occupies a dwelling house, particularly if at great expense in proportion to his means, or if he buys a dwelling house and fits it up to suit the wants and tastes of his family, than if the same person, the other circumstances remaining the same, took lodgings in a hotel or boarding house. SS 415. Residence in hotels or temporary lodgings. There is nothing in the latter mode of living per se inconsistent with an intention to remain permanently, but it is not as strongly indicative of such intention as the former. This subject was discussed to some extent in Aikman v. Aikman, where Lord Wensleydale used this language, I do not say that in order to obtain a domicile in a country a man must necessarily have a house of his own and reside in it. Circumstances may be so strong as to show a fixed purpose of abandoning his own country and making his home in another, and to show also the accomplishment of that object, though he lives in inns or temporary lodgings. But such cases are rare. Lord Cranworth said, "In the same case, I will not say in point of law that a person may not acquire a domicile by residence at a hotel, but it can rarely happen, as a matter of fact, that such residence is intended to be of a permanent character. But in view of the fact that at the present time so many persons permanently resident live in hotels and boarding houses, the ground taken by their lordships seems too strong, particularly as applied to quasi-national and municipal domicile, and it might be better to say that such mode of living is in itself but equivocal." SS 416. Residence in leased houses or lodgings. The same may be said of leases of dwelling houses or lodgings for short terms. No evidence of animus maendi can ordinarily be drawn from such source, although the opposite inference does not necessarily result. However, the leasing may be attended by such circumstances as would show great uncertainty of purpose, and to that extent aid in defeating the proof otherwise tending to show a change of domicile. Thus, in Wicker v. Hume, the fact that the testator, a domiciled Englishman, upon going to Paris, took a lease of a house there for 3, 6, or 9 years, with the option of quitting it at any time upon 6 months' notice, was relied upon to some extent in the House of Lords as indicating temporary animus maendi. On the other hand, taking a lease for a long term, building a large and expensive house and residing in it with wife and family were relied upon in Platt v. Attorney General as strong evidence of permanent residence. In de Bonneville v. De Bonneville, Sir Herbert Jenner considered the leasing of a dwelling house in England for 8 years strong evidence of animus maendi if followed up by continued residence, but held it to be overbalanced in that case by other circumstances. SS 417. Ownership of dwelling house or other real estate. Papinian says, "Sola domus possessio, qui in aliena civitate comparator, domicilium non facit." The mere fact of ownership of a house or other real estate at a particular place is of little importance, but the manner of, and circumstances attending, the acquiring or disposing of it, the treatment of it, and in some cases the failure to get rid of it, serve to some extent to let us into the mind of the owner. When the question is as to the abandonment of the domicile of origin, the ownership and retention of real estate there, particularly a dwelling house, however acquired, is of some value, inasmuch as it adds another tie by which the person is bound to the home of his youth, and to that extent strengthens the presumption of non-abandonment. And the value of such evidence is increased when the person whose domicile is in question improves such property, or renders it more fit for occupancy, or adds to it by the purchase of neighboring real estate. The same rule applies to a certain extent also to acquired domicile. Thus, in Maxwell v. McClure, the retention of a dwelling house at the place of acquired domicile was considered a strong circumstance against reverter. The importance of ownership of real estate as evidence of animus revertendi is, however, affected so much by special circumstances, often slight, that it is impossible to draw any lines or lay down any definite rule with regard to it. It has been frequently held to be destroyed by proof of purchase of real estate accompanied by residence elsewhere. SS 418. Sale of dwelling house or other real estate. The sale of real estate, particularly a dwelling house, at the place of domicile, whether acquired or of origin, accompanied by removal elsewhere, is some evidence of animus non revertendi, but is not conclusive. SS 419. Purchase of dwelling house or other real estate. The purchase of real estate at a new place, accompanied by residence there, has been accepted in many cases as evidence of animus maendi, particularly where the person whose domicile is in question has expended a considerable sum of money in improving such estate and in fitting it up in a manner suitable for the permanent residence of himself and family. But such evidence is not decisive if from the other facts in the case animus revertendi appears. Thus, for instance, in Gillies v. Gillies, a person was held to have retained his Irish domicile of origin notwithstanding that he had resided in France for 19 years, during the last 12 of which he had lived in a house purchased by him there, it sufficiently appearing to the court that his residence in France was for the benefit of his health, for the improvement of which, to the extent of permitting him to return to and remain in his native country, he had constantly hoped. The same may be said in case the purchase is for the purpose of future and not present residence, or for a mere investment and not for a home. The purchase of real estate at the place of domicile of origin will naturally strengthen the presumption of animus revertendi, but will not necessarily render it conclusive. SS 420. Location of personal property. The location of one's personal property is a circumstance to which in modern law usually little weight is attached in determining his domicile. In the Roman law probably it was different, the location of the fortunarum summa being one of the chief tests of domicile laid down in the definition contained in the code, and doubtless the phrase was largely applicable to movable possessions. The conditions of life were then very different, and the means of personal locomotion and of transferring personal property from place to place and from country to country are now so much improved as to render the same principle no longer applicable. Still, like other circumstances in the life of a man, the collection of his personal property at a particular point may give some indication of his intention with respect to his residence there.